Well, thank you everybody for attending this CLE today. It's sponsored by the University of New Mexico School of Law and the Leifer Border Justice Initiative. My name is Bonnie Steepleton and I am Director of Student and Career Services at the law school. And it's my privilege to work with the team on this project at the law school and in Colorado with the Leifer Justice Initiative. So the Leifer Border Justice Initiative is a project that's sponsored by the law school and the Jacqueline Marie Leifer Foundation. And its mission is to address the ongoing humanitarian crisis at the border. Women, children, and families are fleeing political and social persecution, and they are being subjected to inhumane conditions and abuse as they seek a better life. This CLE will be recorded, so please turn off your video feed if you don't wish to be seen on the recording. And if you need help with your CLE certificate, please contact Cheryl Burbank at burbank@law.unm.edu. And I think she's going to put a copy of the form you need into the chat, and you can download it there. If you'd like a copy of the PowerPoint, or you would like to volunteer with this project, or if you have any questions about the Leifer Border Justice Initiative, please contact my colleague in Student and Career Services, Patrick Lopez, at lopezp@law.unm.edu. So it is my great pleasure and honor today to welcome Ann Taylor. She is New Mexico's new Chief Disciplinary Counsel, and Kim Chavez Cook, who is the Appellate Division Director of the Law Office of the Public Defender and Department of Policy Advocate to the New Mexico Legislature. They will be speaking on the importance of correct, competent advice to defendants with immigration issues and what to do if things go awry. So with that, I'll turn it over to them. And again, thank you for joining us.
Yes, I guess I'm starting here today. Good afternoon. My name is Ann Taylor. I am the new Chief Disciplinary Counsel. I came on just November 1st, took over for Bill Sleece. So I am still trying to get everything sorted out. I've been with my office for almost 19 years now, so discipline work isn't new to me, but the chief's role is. I'll say that taking over in the middle of a pandemic is not ideal, but it has definitely been a learning experience all around for all of us. So I'm happy to be here. I was asked to speak here specifically about like sort of surviving mistakes. And in doing that, what I sort of did was I went through the analysis that I would go through if something came to the attention of our office. And so I'm going to take you through that sort of analysis of what we're looking for, what we think would be a problem, and as we understand the law. And so I'm going to invite anybody to correct me if I'm missing anything. I obviously don't practice in the area of criminal law or in immigration either. And so if there's something that needs to be said or added on to, I invite you to do that. And I'm going to apologize if any of this is redundant or seems relatively simple for you all. But it's the kind of analysis that I would go through if I just got a complaint about somebody failing to advise their client properly in my office. And so with that, I would say that I would sort of start with, more or less the background. And the background, as I understand it, in New Mexico was actually a little bit ahead of the times. Because in determining that attorneys do have an affirmative duty to advise their clients when they have potential immigration issues. That actually evolved even during my time as disciplinary counsel, because the first case that I found that addressed that was in 2004 in the State v. Paredes case. And it specifically was talking about the affirmative duty for a criminal defense attorney to advise their client. And then I've seen, as I researched the matter, I saw it the evolution of it in terms of what the advice is and what constitutes competent advice for these types of clients. And so when I looked at it, it sort of evolved from sort of in New Mexico and as I can tell nationally, it's not just the bad advice that you might get. Which is in the simplest forms, no, you're not going to be deported, don't worry about it. That was, I think, pretty early on determined that if that was the advice, then of course that constituted a problem in advising your client. But it evolved from there to also, what if there's no advice? No advice meaning, I don't know, check with an immigration lawyer. And then it was determined that that was also deficient in terms of the representation. And then we also, we're looking at, it's not just related always to the fact of deportation. That evolved later too. And, you had to look at it and say, not only could you be deported, but you also might have other issues. One of them being you are never, ever going to come back into the country if you do get deported. And so as I understood the case law, that what the court was basically saying was you need to know your client's immigration status and know all of the potential specific consequences. You can't just say you could be deported. That's not enough. You've got to know the specific consequences when you come to advise your client. And so that's what I looked at in terms of what we would be looking at in terms of counsel's performance, and is it deficient? And what does that mean for us as in terms of the disciplinary counsel? Well, why do we care? Because obviously most of these cases are appellate court cases where they're talking about ineffective assistance of counsel. They're not necessarily talking about your obligations under the rules of professional conduct. And so what we look at is, well, how does the failure to advise relate to the attorney's ethical obligations? And the attorney's ethical obligations, the rules that are implicated, there's going to be two that hit right off the bat. The first one is going to be, it's lawyering 101. It's your competence rule. It's rule 16-101, which requires the lawyer to competently represent the client. And what does that mean? What does competent representation mean? Well, under the rule and under the commentary to the rule, it will tell you need to have the knowledge and the skill and the preparation to be able to competently represent your client. And so if you take that ethical rule and put it in the context of the case law with respect to this issue, then you need to know, what advice did I give my client? Does that meet the ethical standards? And like I said, as I have understood the case law and the evolution of the case law, it's very specific. So you're going to fall below that standard if your advice is not specific to your client and your client's specific status in terms of what a guilty plea might mean for their immigration. And then the second one, and it's a really important one, is the rule regarding communication and your client's informed decision-making. And that's going to be Rule 16-104B specifically. And that's the other rule that we would be looking at. Did you violate this rule? Did you give your client enough information so that the client was able to make an informed decision in whether to accept a plea agreement or not? And so we would be looking at those on a case-by-case basis, obviously. And so what I would do is I would go back through and I would look at the case law and I would look at it as I understood it. And then I would look at the actual facts of that complaint as it comes in. So, what was the duty and how did this attorney meet it or fail to meet it? And what were sort of the steps the attorney took? And I think that's, one of the things that I really want to address here, because we've talked a lot about over the last few years being proactive in terms of attorney regulation. And what we want people to understand is how to avoid getting into trouble. So I would look at what the attorney had done in terms of their research, in terms of consulting with other counsel, and in terms of what communication did we see that this attorney specifically had with this client. And to that end, I think that's what I would always recommend if you want to be proactive about this. What steps can you take? And the first is to research. If it were me and I were taking on this kind of a client, who had this kind of case, I would be doing as much research as I could into what are we talking about with what specific recommendations what specific advice do I need to give this client before I feel like I have competently advised them about whether to accept this sort of guilty plea, or what can I do personally to make sure that I'm not wrong? And that could be consulting with somebody who specializes in immigration to tell you specifically, this is what will happen for sure if this client accepts this plea, goes down this road, whatever. And then I would have, honestly, if it were me, I would have a checklist. I would have some sort of mechanism for writing it down. And I understand that when we are talking about some of these clients that are not necessarily the most sophisticated or don't necessarily speak English, then it might not be the traditional communication, but I would want that in my file of what I specifically advised my client, and for what reason, what was I looking at, what law was I looking at that says that this is what the consequence is, and how did I communicate that to the client? And if the client is a non-English speaker, who did I talk to? Documentations of those kinds of things. And then I want everybody to know, because again, I'm not trying to we've tried so hard, like I said, to make this sort of more of a regulatory thing, not to frighten people. So what would happen if it came to our office's attention and we did this sort of analysis of, well, they fell below the standard of care and they fell below their communication level was not sufficient. What sort of action should the attorney take, and what sort of action would we take? And the first thing I want an attorney to know is if this has happened to you in terms of a disciplinary context, first of all, don't panic. And there's a couple of things that I have to say about that. One is, depending on how it comes to our attention, if it's a complaint from the client themselves, one of the things that we know, and is probably well known among clients if they talk about it, is that if we were talking about specifically about the immigration, in the immigration world, there's actually a duty to file a disciplinary complaint if your immigration counsel has engaged in effective assistance of counsel. That's actually a pretty well-known case out of the immigration court, Lozada. There's not that same sort of duty in terms of New Mexico courts being able to look at the conduct and determine whether it's been an ineffective assistance of counsel. So there's no requirement that they file a complaint with us, but people might do it anyway because they think so, or because they've heard about it on the immigration side. And so I wouldn't panic if I were the attorney who got the disciplinary complaint based on this right off the bat. Again, I want everybody to know that what we do is we look at things on a case-by-case basis. So what the inquiry we're going to do is, did you do any research? What research did you do? Did you know, what did you rely on? Did you consult with somebody else? Did you, did you have any sort of written communication with this client about why you were making these specific recommendations? And so, that's what we're going to ask you. So you would get, like any other disciplinary complaint, we would get, if it came into our office, we would ask you for a response. And you could send us whatever you had in terms of documentation about why you did or did not make a specific recommendation. Now, if you know that you didn't, that your advice was bad, or you failed to advise properly of the consequences of accepting the plea agreement, the best thing from a disciplinary standpoint, the best thing to do would just be to be forthcoming about it, and to advise us, the reason behind it. And what I want everybody to know is that if you look at the reason behind the reason why the immigration courts require disciplinary complaints to be filed, it's not because a one-off mistake will in fact result in some sort of disciplinary action by our office. It's actually so that we can determine whether this is a chronic problem or whether it's a simple mistake, because we have disciplinary case law that actually says, isolated errors don't necessarily lead to discipline. So one does not need to worry about the fact that you're immediately going to be subject of discipline if you've had just one error, if you had one thing that went wrong. But if we have a pattern of them, and we wouldn't necessarily know until in the disciplinary context until we've had a few complaints, that's when we would be more likely to take action. Is this attorney chronically failing to advise their clients? Do we have chronic orders from the court finding ineffective assistance of counsel from this one particular attorney? Those are the kinds of things that we would look at. And so I would just say to all of you who have the fear of the disciplinary complaint coming, just be forthcoming and respond to it. And then, one of the things that we look at in the disciplinary context is even if you have, let's say, more than one, say you have two, is what are they doing? What steps should they take? It's always going to be a mitigating factor if you take corrective action. And so, did you inform the client? If you have malpractice insurance, did you put your malpractice carrier on notice? Those kinds of things. And so the very worst thing that you can do from our perspective is to take no action, is to dig in your heels and say, I made no mistake, I took no action, I took no corrective action. And that's when we're more likely to say, okay, well, we think this needs something more. And again, even if it's a couple of times and we think it needs something more, from the disciplinary context, it may just be that we can set you up with a mentor, somebody who can help you understand this area of the law and get you up to speed. We can set you up with somebody who's more well-versed in immigration law. So it's not always just a jump to immediate discipline, a jump to taking your law license away. And so that's sort of like what I said, my analysis would be, if I got this, what's the reason? What steps did they take? What do they have? What plans do they have in the future to avoid these kinds of mistakes? And that's what we would be basing our discipline on. So,
Ms. Taylor, there's a question in the chat. It says, let's say that an IAC claim was brought against you for the purpose of a plea withdrawal. What is your ethical obligation to communicate with the new counsel or defendant who is bringing the IAC claim?
I'm sorry, can you repeat? I missed part of that in there. Can you repeat that?
What is an attorney's ethical obligation to communicate with a new attorney for the defendant who's bringing the IAC claim? So let's say you mess up and an ineffective assistance of counsel claim is brought. Do you have an ethical duty to cooperate with the new attorney for your client?
That's an interesting question, because in that sense, you could run into a conflict of interest, because on the one hand, you're still acting sort of like the representation is continuing, helping the client with what you have done in error. On the other hand, you're limited. The rules of conflict of interest rules prohibit you from sort of engaging in representation when it's limiting by your own interests, and your own interests may be different from disclosing to the new attorney. So I think that to the extent that you feel like you can, that you're okay in doing so, but that you may run into some sort of conflicts between your own duty and that of the new attorney.
And if I can take a stab at just supplementing that a little, April, it'll maybe, some of it'll get maybe covered in the second part of the presentation. In the past, this has come up many times, and in the past, I have always advised counsel that they don't have to, volunteer themselves to fall on their sword. Of course, I always, if that's your inclination, I think that's lovely if you're not concerned about the disciplinary consequences or what have you. But that if you are concerned about that, you can wait to be subpoenaed, and then, you just answer the questions that the court is maybe instructing you that you need to answer as part of a subpoena process. And that sort of thing, if you're called as a witness, in other words, and that any information that might be asked about by their new attorney that would have been privileged or confidential under the pre-existing attorney-client relationship, that, you know, just make sure that it's clear that the client is waiving that privilege and that confidentiality in order to answer those questions. And then if you feel like you need your own counsel because you might be subject to liability civilly or something like that from your responses, then that's sort of the path that I advise people down. Certainly for public defenders, we we don't typically get sued in a malpractice kind of way. So that's sort of a more complicated position to be in when you're in private practice.
And if I can just add just a little bit to what you said about the confidentiality provisions, one of the things is if you look at the rule regarding confidentiality, you are permitted to disclose to the extent reasonably necessary to defend yourself. And so that you don't have to have the fear, it actually comes up in disciplinary cases a lot, that you don't have to have the fear that you're disclosing something if an allegation has been made against you. So you do have the ability to disclose. Like I said, I would be a little uncomfortable if you were sort of still acting like you're representing the person, but you may have developed sort of a conflict of interest because it's against your own interests. And then you're kind of limited in what you might be able to do for them. Are there any other questions? I know I was given 20 to 25 minutes, so I don't want to take up all my time. Okay, and like I said, one of the things that we have really worked towards is helping attorneys understand that we're trying to engage in more proactive measures. And to that end, I think there are two resources I would like to just point out that we have. They're the Ethics Advisory Opinion and Committee, and they would go ahead and if you write to them, they will actually give you an ethics advisory opinion if you're struggling with an issue. It doesn't work very well if you're sort of in an emergency situation. If time is limited, my office will actually take hotline ethics calls and answer the question to the best of our ability with the information that we are given at that time. So if you're out there and you're struggling with an ethical issue about how to handle a particular issue with your client, you can call our office and we will do our best to get you a quick answer just based on the facts as you represent them at that time. But those are some resources that you can use if you're struggling with the issue. All right.
Well, thank you for that. If there aren't any further questions, we're very happy to have Ms. Kim Chavez-Cook for the next aspect of our presentation.
Thank you, April, and thank you, Anne. So I think the sort of segue here is to Anne's focus was on sort of the attorney's disciplinary exposure, and ineffective assistance of counsel, which is my topic for the day, is focused entirely on what remedy might be available to a client within the bounds of their criminal case in which they received that representation. So I want to also, sort of as a context before I get into the law of things, say that counsel's obligation about advising on immigration consequences is not about guaranteeing a particular outcome in the criminal case so that those consequences don't come about. And it's not just about whether they should say this is a good plea or a bad plea. It's about advising the client and providing them with the information they need so that they can make an informed decision about whether to plead, whether to take that plea, or whether to risk going to trial. They would face the exact same consequences if they're convicted of that same thing at trial, but because they waive rights with a plea and because the consequences are knowable with a plea, there's always the chance you could get acquitted at trial, but you know that this conviction is happening at the plea stage. That's what triggers this duty to advise on this sort of higher level, and why the cases about ineffective assistance on the issue tend to surround the plea moment in the representation. So under New Mexico law, which is my focus, and I'll touch on federal a little bit for those of you who maybe practice also in federal court, As Anne mentioned, the sort of seminal case for us here is State v. Paredes. It's a 2004 case from the state Supreme Court in which the defendant pled guilty to criminal sexual contact of a minor in the 3rd degree. And that is just sort of as, threshold information. I'm not an immigration lawyer, and many of you might be. But under the federal code, that is very deportable. that is a crime that will get you removed unless you can maybe submit a counterclaim for for amnesty of some sort to stay. But the language is shall in the statute, shall be removed. The crime is an aggravated felony because it constitutes sexual abuse of a minor, and aggravated felonies are ineligible from discretionary relief from deportation. So that's a deportable offense. So with that context, the opinion in Paredes is really trying to explore when at that plea hearing, and in the lead up to it, what was the district court's obligation, what was trial counsel's obligation, and sort of distinguishing between those two. So while the focus here is ineffectiveness, I think it's helpful to also understand what role the court itself plays. So I'll start there by just laying out that, that's governed by due process. It's the Sixth Amendment right to counsel governs ineffective assistance, but the court's obligations are governed by due process. And in New Mexico, Rule 5303 basically dictates what is required to satisfy due process. And at the time Paredes came out, it required the court to inform the defendant, this may affect your immigration consequences. That's all the court had to do. And Paredes affirmed that's all the court has to do. So could affect is good enough for the court. But Paredes also then holds counsel to a higher standard. The attorney has an affirmative duty to not only determine the client's immigration status, but then to provide specific advice about the impact of that guilty plea. This is because defense counsel is in a better position to determine the person's status, what their family situation might be, what other things might be available to them in an immigration context. And so we do hold them to this higher standard. They are also the ones that have an advisory relationship with the client in a way that the court does not. So the ineffective assistance analysis is based on a standard of reasonableness. It's an objective standard. And so I think Anne also mentioned at the very beginning that obviously affirmatively telling them the wrong thing, oh, don't worry, you won't get deported. Like that's obviously going to be fail that objective reasonableness test. But when the advice is either silence or just a wishy-washy, something might happen, I'm not sure, that's when we start to get into this gray area. So in Paredes, what the Supreme Court did was reject the 10th Circuit approach, which was at the time was to find that failing to advise at all was not ineffective. Advising incorrectly, ineffective, but not advising at all was fine because it was just a collateral consequence of the conviction, so you don't really need to worry about it. New Mexico departs from the 10th Circuit and requires not only advice, but also correct advice. So both are required. And there's 3 reasons why the court did that. One is that if the attorney provides no advice or general advice, the result is the same. The client doesn't know what to do. Second is that by saying that non-advice is fine, but misadvice is bad, we're just incentivizing not advising the client and putting them in that position of not knowing whether to enter the plea. And finally, they identify that this is a particular group of clients who are the least able to independently discern what those immigration consequences could be. They're very unlikely to be able to just pay an immigration lawyer or read the statute book and figure it out. So in New Mexico, attorneys are obligated to determine immigration status, and if a non-citizen, then they have to advise them of the specific immigration consequences of pleading guilty, including in the language, the magic language is to say when deportation is virtually certain. So that is the ideal language if it's a very strong likelihood of deportation. And that's the only way to ensure that the plea will be knowing and voluntary. An ineffective assistance claim also has a second prong, which is prejudice. So the defendant would also, in order to get out of that plea, when this does happen where they're misadvised, they do have to show a reasonable probability that, but for that failure of counsel, they would not have pleaded guilty and would have instead pressed to trial. So with that context and applying that to the facts of Paredes, they found a strong inference that the advice was not given, because at the plea hearing, the attorney informed the court that I told him he might be deported. That's not good enough under New Mexico law. And then the defendant moved to withdraw their plea almost immediately after the case, after the plea and the sentencing, which was a strong inference of the prejudice prong as well, that they would not have entered it had they known. And then, the case was sent back down just to allow the counsel to clarify the record if there was actually advice given and that sort of thing. So that's Paredes. Be advised that after Paredes, they updated Rule 5303 to add to the court's obligation to not only tell them you may have immigration consequences, but to also inquire if the defendant had been advised by counsel. So that question gets asked now. So that can help avoid cases where the conversation never even occurred. But practically speaking, that also might increase the evidentiary burden for a defendant to show that they were not properly advised, because if that colloquy happens and everyone says, oh yeah, we talked about it, then it might be a little harder to show that the advice was insufficient under the new rule, but at least they're checking before the plea gets entered now. And then the follow-up case, the only one that I really wanted to touch on, is State v. Favela, which held that in a case like this where the counsel fails to give this information to the defendant, the judge can't cure it by at the plea hearing trying to give that information for them. That is something that has to happen within the context of the attorney-client relationship. And so that's the IAC sort of law on it. And I think practically speaking, the thing to keep in mind is, again, if the advice it doesn't come out right or isn't thorough enough, and the client does end up having an IAC claim, there's sort of to the question that was asked earlier, it really could benefit the client to say, yeah, I thought that I gave the right advice, but I didn't, or I looked it up and I thought I knew it, or whatever the case may be that led to that incorrect advice. If the client really is in a position where they didn't have the information that they needed, the ineffective assistance of counsel claim is their only avenue to withdrawing that plea and avoiding that consequence potentially. So that's pretty much my spiel.
Well, thank you for that. We have a question in the chat. In New Mexico, has correct advice been specifically defined? In other words, what if some advice is right and some advice is wrong?
I will say, I don't think it's been defined by case law in terms of like how much would have to be right or wrong. I think it would be a case-by-case assessment under that first prong of ineffectiveness for IAC purposes. And I'll let Anne chime in on the disciplinary end, but it's going to be that reasonableness standard of did it fall below what a competent attorney should be expected to advise. So where along the spectrum it falls will be case-by-case determination.
I'd say it's virtually identical in the disciplinary context. We don't have any definition of what was correct or what was not correct. We deal in extreme disciplinary cases. They're extreme, and so it's obvious when like the advice is no, you won't be deported, for example, and it's clearly part of the law that they would be deported. That would be an extreme case that we wouldn't necessarily even need to bring in somebody else. If it were a trickier case, and we'd probably ask for somebody who specialized in the area, just like you would in civil litigation if we needed to define it. But no, it hasn't been defined.
Yeah, and that makes me think of a follow-up, which is just to say, in the IAC context, I could see that affecting actually both of the prongs of the test, not only the objective reasonableness, but like if the thing that you got wrong was, you know, that wouldn't like have created this substantial likelihood that the defendant would have done differently, you know, I then probably it won't result in ineffectiveness or withdrawal of the plea. So I think it would depend on sort of like how significant the incorrect piece was versus the correct piece. You know, those are sort of the factors that I think would get looked at in an IAC context. So it's really in the abstract, it's a very hard answer to give clearly, but.
And just again, to piggyback on that, again, the rules of professional conduct are rules of reason. And so one of the things that I said was, you know, I just did some research on this, and it seems to me that it's evolved over time, specifically with what you have to say. Wasn't necessarily like in 2004, they didn't have necessarily that you had to also say, well, you're going to be forever barred from coming back into the country. That wasn't part of what the standard was. And so if we're looking at it after the fact, if it's basically the court rules and says, we also want this, again, we're rules of reason. If you didn't know that at the time, then of course, we're not going to necessarily say that there's something that fell below the competence standard, because that's new law.
Yeah, and that's similarly how they approach it in the IAC context. There was a sort of companion line of cases for other collateral consequences, including sex offender registration and the duty to advise there. And the case on that really did talk about, well, what was expected of an attorney at the time of that plea? Was it common practice to advise of this collateral consequence then? Because even if it's common practice now, we're not going to hold the attorney to that standard retroactively. So yeah, that's the kind of inquiry that would happen.
So thank you both for your presentations. We have left plenty of time for questions because this is such a complicated area of the law. We're very thankful that Becca last week tried to lay out some of the content of what people need to be advised. But what's also become clear is the context in which the lawyers are actually trying to make these advisements. And we can understand why the courts will put the responsibility on the defense attorney, because they are in the best position to know. But from what we're hearing, these advisements are occurring, you know, in a room right outside the courtroom. The people are, you know, knocking on the door. The bailiffs want the judge wants the person before the court. If they're not able to enter into a plea, then the client is going to go back to jail. So that the conditions around these kind of very complex decisions are really tough, especially for people in the criminal context. So I don't know if you want to speak to context and how that plays a role in either of these fora, but I think it's been a reoccurring concern that it is just both very complex, and the timeframes and the circumstances in which these discussions are happening are really confine what happens.
Absolutely. And I think that actually overlaps a lot with the question that just came up in the chat from Ann Delfa. So I think, yeah, it's really challenging if it's a like meet and greet plea situation, right? That's obviously going to make that incredibly difficult. And I think in an ideal world, what you would do is try to get more time. If you realize, oh, I'm meeting this person, they're about to head into a plea, and I've just asked them about their immigration, about their citizen status, and found out that they, you know, are an LPR, they have this like limited visa of some sort or what have you. And so now I feel like I need to like consult the immigration code real quick, which is not a thing you can do real quick. So yeah, I mean, I think you would need to ask the judge for a moment to do that, honestly. And then I think, you know, within the public defender department, we have made it a practice to consult with, we have an immigration attorney on call who we can reach out to, but on call doesn't mean they answer the phone the second you call them. So yeah, I mean, it's a process that takes time to get that consultation. And to some extent, and this goes again to Anne's question, that there is a certain onus placed on criminal defense lawyers, even though your expertise is criminal law, to develop some basic knowledge in the immigration law area when you practice in a border state. I mean, really anywhere, although I will say the federal law is a little more forgiving than we are in New Mexico, and that might largely be because we are a border state. And, you know, so Padilla v. Kentucky, which I didn't really get to in my initial spiel, does say, you know, if it's easily discernible, then you have to give them the thorough advice. But if it's not, then it's enough to say that it may carry a risk of deportation. It's sort of that same standard that the court is held to if it's not something that you could easily look up. So I think, yeah, there is this sort of heightened burden in New Mexico. And my advice going to Anne's question on making sure that the client understands, I mean, I don't think you need to like quiz them on it afterwards and say, repeat back everything I just said to you. I mean, I don't think it's anything quite that stringent. I think you'd want to make sure they understand it to the same extent that they understand the pieces of criminal law information that you're advising them on, of, you know, what the sentence would be and what the lesser includeds are and what the defenses available would be, all the things you would talk about in a plea discussion anyway. You know, if you have a client who keeps just being with like sort of deer in headlights, and you don't think they're absorbing any of that information either, you know, you take a step back, you take a breath, and you try to explain it maybe from a different angle. If language barrier is an issue, get a translator in the room for sure. So you want them to understand it, but do they need to understand it on the same level a lawyer would? I don't think so, but they need to be informed enough to make this huge life choice.
And I'm just going to say from your ethical obligations are to communicate to your client. And if you can show communication, you know, that's going to be enough for us in terms of, you know, you can't ensure understanding of various areas of the law all the time. What your duty is to explain it the best that you can and hope that your client understands. And that's what we would be looking at is what did you do? Was it reasonable in terms of communication? You know, was it like, you know, Kim said, you know, did you consult with another immigration attorney and you made sure that was correct and you wrote it down and you were able to tell the client this is what happens, and you said it through a translator and you had it written down in the native language and you did all of that. Well, that's going to meet your communication standard under your ethical obligations.
So there's a question in the chat. Would you ask for verification or confirmation of immigration status rather than taking one's word of what status they believe in?
A really great question. I mean, I don't think you're obligated to for ineffective assistance analysis purposes. And, you know, again, Anne might have a different answer on the disciplinary end. I would say, unless you have reason to question it, unless you know, for some reason you think like, gosh, that temporary relief status that they're saying that they have expired in 1986, like maybe they don't realize that green card that they've got is no good anymore. So unless you have a red flag like that, I would say you probably aren't under an obligation to like demand the paperwork.
I guess my question would be, what is the fear that they're going to tell you that they're a citizen and they're not? And I guess I'm trying to imagine the context of that, and maybe it's if they became very young and maybe they were unaware. But I can't imagine, like, unless there was a huge red flag that under your ethical obligations, if they told you one thing, that you would be having to independently research that specific issue. I mean, you are entitled to rely on your client's representations to a certain extent.
So one of the things that we talked about last week in the conversation about the duty to advise was that one way to get at this conversation with your clients is to ask them where they were born. because it's a non-threatening way to try to discern status. And so I put that out there to try to also create continuity between these two sections, and also partly in the hopes of helping people who want to engage in representation in this area. I mean, part of it is to help people like myself who are interested but terrified know what are some of the tools, but also what's helpful about today is some of our main fears as lawyers are we going to be disciplined if we screw it up, or are we going to end up, being ineffective in our representation? And so we hope, as part of our border initiative, is to try to raise the standard of practice. So we don't want to say that the standards that we're aiming for are those to avoid disciplinary claims and avoid ineffective assistance of counsel. But what we hope, and what I take away from today, is this is a very complicated area of law. Our disciplinary counsel understand that this is an area, that the circumstances in which you're doing this is difficult, and that the main takeaway here is that the disciplinary counsel is looking for patterns. And so a single one-off mistake is something that we can come forward about and address, and hopefully, if necessary, if you've done something that arrives at the level of ineffective assistance of counsel, there are means through which your clients can be guided through that process so that there's not the kind of ongoing harm. So I hope that is accurate. It looks like there's another question in the comment in the chat. Sometimes clients believe what their parents tell them about where they were born, or if their parents are citizens or not. So thank you for sharing the where you were born question. So are there any other questions? Or can you both see the chat, or should I read it?
Sorry, I can only see part of it.
Yeah, I was going to say, I only am seeing the last question from Anne. So if there's been something since that, then I don't see it.
Okay, so then maybe that's my bad. So then, are there any other questions from the group? Because we do have a few more minutes. Again, this is a very difficult and complicated area of the law. Becca Kitson is one of the best teachers I know, but I also did find it somewhat difficult to follow, not being an immigration attorney. The complexity of the advisement is a challenge. So what we're trying to do as part of our border initiative is to follow up on that, to help provide more information and teaching to the community about the advisement. So we hope to have that be part of our ongoing series. We do have another couple of CLEs that are coming up. And I don't know if, Bonnie, do you want to share screen and show those? So I don't know if you wanted to talk about those, Bonnie, or if you want me to.
If I could just, I saw, I think, the question about the emotional struggle that I could address, because the question was, could you talk about the emotional struggle that many attorneys go through when we think we messed up? I would like to address this because when I do, especially when I talk to the law students, but even in general CLEs, I always bring Hershey's hugs and kisses from the disciplinary board, because I like people to know that we're real people, and that when we take a hard line, we take it for a reason. And and I understand that many people, most people, are competent practitioners who may have a one-off. And so that's why I said, at the beginning, don't panic, because, some of the people think that there's an automatic need to file a disciplinary complaint in an ineffective assistance of counsel claim in the criminal context. And so they might file it just for that. They have to in the immigration context, so they do file it just for that sometimes. That doesn't mean that we're going to make an immediate finding that anything has gone wrong. Even if the court has found ineffective assistance of counsel, that also doesn't necessarily mean that there is, we're going to discipline you. We understand. And then, like I said, the case law actually says this, that like, well, you can incur civil liability sometimes for one-off mistakes. That doesn't necessarily mean that disciplinary action is appropriate. And even if disciplinary action is appropriate, we don't jump to disbarment as our first line of discipline usually, so there are other avenues. And so I think that I can understand that there's sort of a fear when you get that kind of panic when you get a letter from our office. There is no reason to panic. And especially if you have, documentation or even that you didn't screw up, then that's an easy fix for us because we can just dismiss the complaint. But if you did, full and free disclosure goes a long way and towards making it right. And everybody who is within our system understands that.
Did you want to add anything, Kim?
I think that pretty much covers it. That's the advice I give attorneys in our, that work under me. Even if they just get a threat of a disciplinary complaint or something like that, and the panic sets in, because we all really strive to do everything right all the time, but it is a lot, and we're all human. And not only that, but a lot of times what sometimes might be perceived as a total failing is really, just the best you could do in the circumstances and wouldn't even be considered a failing. So, keep that all in context, and if something does go horribly wrong on the, that if you do have that situation, learn from it, use it as a learning moment, and just do your best to get back on your feet and learn from it and not let it happen again. If it means that you have to, make a change in the procedure that you're following in future cases, then all the better for your future clients, and try to look at it that way. I know that sounds very like lemons to lemonade, but I think that's the best way you can approach it, really. Obviously if there is that pattern, and if something like that is going on, I would, I'm sure Anne can mention in specifics, but there are a lot of resources out there for attorneys within the legal community for whatever might be the underlying reason, too many cases, whatever it is. So yeah.
Yes, that actually gives me an opportunity to advertise another sort of proactive program, and that is that my office works very closely with the JLAP, the Lawyers and Judges Assistance Program. And one of the things that they have done in addition to helping with substance abuse is they do a lot of mental health referrals, and they also offer the sort of counseling sessions that are free to all members of the state bar. I think you get 4 through your state bar membership. And so that, they are available as a resource. And then finally, I can leave this issue, but the other thing I want people to know, and I always tell this to law students too, is that, 80% of what we do is understanding why a lawyer did not screw up. I mean, most of the complaints that come through my office are not acted upon. And so we have a better understanding probably than a lot of people do that not all complaints are merit. And not all of them merit discipline, but not all of them have merit.
And, this sort of dovetails off of the question that just came in from Savannah Duran, which is, the other thing we see, we're public, in my office, we're public defenders. We all have too many cases. And so one of the things that I think is important is, using those resources early, whether you're in private practice and so you're turning to the bar and the resources in the community, or if you're in a firm and you have a mentor or a partner who you can turn to in a state agency. There's mentorship built into almost all the state agencies that I know of. The bar has a statewide mentor program for newly starting out attorneys. The most critical thing I can say is reach out for the help early. Ask for assistance early. Don't wait until you're already completely underwater, because that's when clients actually start to feel the impact. If you can see it coming, that's a better time to reach out and ask for help.
That is really fantastic advice, and this has been a very helpful session. Hopefully, It will help people feel more ready to embrace the difficult challenges of learning to serve immigrants at our border, learning to serve within our border community. We do have other opportunities for those of you who want to volunteer. We have some great projects going on as part of the initiative. We have opportunities to work on asylum cases, work to end the practices of taking people's property away and deporting them, some of the other things that are going on in the border. And we'll be talking about that next Thursday at our volunteer meeting. And we'll be sending out a flyer on that. There's also an opportunity to earn more CLE credits. So Bonnie's got the flyer ready and she's going to share screen. With that, I really want to thank Ann Taylor and Kim Chavez-Cook for coming today, and hope that you all have learned a lot and feel at least ready to brave this exciting and necessary but somewhat intimidating area of law. All right. With that, unless there are any further questions, oh, there's something in the chat. Oh, everybody's saying goodbye. Thank you for coming, everybody, and we will either see you next week or we will see you in our next sessions, which we hope to make even more progress in helping people serve in this important and complicated area.